the day Mr. Salman Khurshid Saheb, our respected Vice Chancellor Sahab, Buddhu Vinay ji, Professor Dr. Buddhu Vinay ji, and Registrar, Brigadier Rajiv Rajiv Sahab, and my academic coordinator of ICFAI Law School, Madam Monica Kharola, the law professionals and academicians from different part of the country and from my university, and the organizer, Madam Ekta Gahlawat, and my dear student friends. ICFAI Law School, ICFAI University, Dehradun, is organizing a national webinar on legal profession during COVID-19 period. We have with us today a very learned and intellectual personality who is a jurist in fact, Mr. Salman Khurshid Saheb, who is the senior most advocate of Supreme Court of India and a great politician, former cabinet rank minister also. I, on my behalf and on behalf of the whole of the university, wholeheartedly welcome you to us today, sir. I understand you are a very, very busy personality, sir. You have got a great job to do for the nation. But even then, you have spared your valuable time and you are here with us for this webinar, national webinar. So I'm very much grateful to you. I thank you very much. I wholeheartedly welcome you, sir. And then I also welcome the distinguished legal luminaries from academics and law profession from different part of the country. I welcome the faculty of our university as well as other university also. And with that, I welcome my students also. And now I will be speaking a few words with regards to my university. This university, ICFAI University, Dehradun, was established in the year 2003 by a great education builder and educationist who has, in fact, established 11 universities. So, and this was established by a law passed by the government of Uttarakhand. From that time onwards, keeping the mission of Mr. N.J. Yashasvi in mind, the university has been maintaining the decorum and standard of education and providing quality legal education with the professional skills in the field of law, management, technology, and education. And this year, for its, it has been recognized by the World University with Real Impact with 44 rank. We call it UNI 44 by the UN Institution of Training and Research. With regards to the law school, this law school for its excellence have been recognized as the first and the best university in Uttarakhand and the 6th top ranking university of super excellence in law by CSR ranking, and the 26th top ranking law institute of India by India Today in schools also. So with this, now I will be speaking about little bit, though we have a very learned speaker on the topic, which are a law profession during the COVID-19. The situation during COVID-19 has been very gloomy, and not only law professional, almost all professionals, they and business people, they have been put to a great hardship. However, even during that time also, ICFAI Law School and other schools of this university, because of their being very professionally competent to have their education through online, and we have been awarded the e-lead certificate also for that. So we could manage under our under university social and academic responsibility to organize many webinars, many workshops, many series of lectures, and so continuously in order to educate by our students as well as others, we have been continuously organizing. In that process only, today we are organizing a national webinar on legal profession during COVID-19, and we are very fortunate that we have with us today a very, very senior advocate of Supreme Court of India for his experiential knowledge on this topic. So I welcome sir on this occasion, and further I request the our Madam Ekta Galawat to take the program further. Ms. Ekta Galawat.
Thank you so much, sir. Now I would like to introduce Mr. Salman Khushrid, sir. Mr. Salman Khushrid is a renowned lawyer, educationist, writer, politician, who in 1953 was born into a distinguished family of educationists come national leaders who have served the country with great distinction for over 3 generations. Sir is exceedingly well read and holds several degrees. He completed his graduation from University of Delhi, before which he was student of St. Xavier High School in Patna, Bihar. After completing his graduation from University of Delhi, Sir went to England for higher studies. He pursued a course in law for the prestigious St. Edmund Hall, Oxford University. He was also a lecturer in law at the renowned Trinity College, Oxford. An active political party worker, Mr. Khushrid served as a president of UP Congress Committee from 1998 to 2000, and later from 2004, having in interregnum served as a chairman of Congress Party Foreign Affairs Cell and General Secretary of the party. Sir was earlier officer on special duty in the office of late PM Shrimati Indira Gandhi in 1981, looking after judicial appointment and international speeches. Mr. Khushrid represents Farrukhabad constituency in UP for the second time in Lok Sabha. During his earlier term in the Lok Sabha from 1991, he served as the Deputy Minister of Commerce and later as the Minister of State for External Affairs. During the current term in Lok Sabha, he has held various portfolios such as Minister of State and Minority Affairs and Corporate Affairs. Later, he was elevated as a Union Cabinet Minister of Water Resources and Minority Affairs. In July 2011, he took over as a Union Cabinet Minister of Law and Justice with an additional charge of Minority Affairs. Shri Khushrid took office as an External Affairs Minister on October 28, 2012. Mr. Khushrid has a passion for writing. His acclaimed play Sons of Babur has been translated into several languages and performed across the country as well as in UK. At home in India, and if writer comes, are amongst the better known books of the author. Sir, it is our privilege to have you with us today and enlightened by your noble thoughts. Over to you, sir.
Thank you very much indeed. I'm very honored that the Vice Chancellor and the Dean of Law School are both present for this discussion, as indeed are all of you and some very, very distinguished friends from the university and friends of the university. The topic that I have is a very curious and interesting topic, the law profession in the COVID period. I mean, in a sense, the COVID period is an unprecedented, unexpected, unplanned, and certainly a period of considerable puzzlement as to what is happening to us. Whenever a human being, and that's our common experience, a human being feels helpless whatever we have been taught, whatever we have by way of experience or by intuition, when we feel that we have no way of responding to circumstances around us, we know that traditionally and conventionally, we tend to turn to spirituality of sorts. We turn to, so as I was saying, I'm sorry of that little interruption, but we turn towards spirituality and we turn towards God. Whatever comprehension we have of God, whatever we know of, or we assume we know about God, whatever we have learned from scriptures, from religions that we have been taught in the family, amongst friends, and so on, we turn to God. This is a period in which, surprisingly, and in an unprecedented way, we were cut off from God. For us, the normal process of reaching out to God is to go and pay obeisance at a gurudwara, at a church, at a mosque, and these were the places that were denied to us largely. They have now been permitted to be accessed by us, but we did not really have, at the worst period when there was the lockdown of COVID-19, we didn't have access to any of these places, which suggests two things. It suggests that by putting a lock on a place of worship, you don't put a lock on God, because God rests and God is available outside places of worship. I mean, that's one way to look at it. And the other is that in fact this is a redundant part of religion, because religion is a lot to do with ability to feel a sense of communication and a sense of belonging to whatever is God, as our perception gives us to understand and to feel. But be that as it may, when we most needed God during the COVID period, we had the greatest difficulty on the normal, conventional, usual, and natural processes and methods by which we could reach out to God. And we had to do it, obviously, in a different way, in private, in our homes, and in many different ways that we must have worked out for ourselves. So when God is, in a sense, being removed at some distance, at least physically in real life, what is the next thing that you look to? Of course, it's natural that you look towards the government of the day. The government as a paternal or a maternal figure in our lives is what we look towards for help, for support, for comfort. That's the relationship that we understand between government and the citizen and the ordinary person. But government again was under enormous stress. Government had not anticipated ever, or even imagined ever, that something of such a horrendous nature would confront it. And therefore, understandably, governments in various parts of the world made some mistakes, made some experiments, tried in their best possible way to respond to this challenge. So that's the government. But part of the government, part of the structure of governance is the courts, which are managed by, as it were, by the community of lawyers. And therefore, it becomes important as to what is the role of a court in these circumstances, and also in conjunction with the role of courts in these circumstances, what is the role of lawyers who populate courts, or who, in a sense, fill the infrastructure of courts through personal appearances. Now, personal appearances were not permitted because of the fear of COVID, the fear of the virus being transmitted, and we therefore turned to what we know as virtual courts and virtual appearances. So we discovered that there was a methodology available by which we could continue to appear in courts, though the courts were physically not accessible to us. Now, interestingly, this was not as easy and apparent as far as religion was concerned, but over a period, we discovered that you could do religious ceremonies virtually, that you could have satsang, and you could have religious gatherings, you could have funerals and funeral participations and puja virtually. We discovered that all that is quite possible, even for doing religious ceremonies. But we are today concentrating on the role of a lawyer, and therefore we discovered, and we know all platforms, including the platform that we are right now using, we discovered these platforms by which communication did not have to break down, and whatever happens by use of communication in dealing with law, in dealing with courts, and dealing with conflicts and disputes, and dealing with the expectation of a resolution of a conflict, we were able to find platforms such as the one we are now using, and those platforms gave us a chance to continue. After a couple of weeks of complete and utter lockdown, when it suddenly seemed that things had gone blank, we were able to switch to these platforms, and those platforms have permitted us to be able to continue with what we do as lawyers. So essentially what we do as lawyers is conflict resolution, whether you do it by way of adjudication in a court, you do it by mediation, you do it by reconciliation, you do it by arbitration. But conflict resolution is essentially what law is about. And in the process, ensuring rights, when there is a conflict between the citizen and the state, ensuring and securing rights of the citizen vis-a-vis the state, and also for the state, where the state has duties to perform for other citizens, as we have in our constitution, the directive principles of state policy, the welfare duties of the government that have to be performed under the constitution have equally to be protected, preserved by lawyers and by courts. And I think, therefore, it's a two-way thing. But we are able to do all this without physical courts meeting is the great discovery, as it were, or the, if you like, a silver lining of the dark cloud of COVID. The dark cloud of COVID is a worrisome thing. It's something that has created a lot of concern in humanity. It has caused a lot of agony, anxiety, and it's caused a lot of pain, as it were, to humanity. But we discovered in the process of the regime that was imposed upon us by a virus, by something that we still haven't figured out, and against which we are still trying to work on a vaccine to protect us, that we had discovered in this process that we had a capacity and ability to do something as lawyers. And I guess this is true about other dimensions of society as well, that we had this capacity that we could utilize effectively. And this capacity was of virtual adjudication or virtual courts. Everyone knew that this was available. We know that paperless courts had been talked about. filing, e-filing is something that we had become familiar with and we had talked about. We were experimenting with paperless courts. Delhi High Court, for instance, had 8 courts which were essentially paperless. Filing in the Supreme Court now much more, but initially as well in the last few years, and now filing in various other high courts has become digital. So you have a digital filing, and the record is digitally available, easy to be transmitted from court to court, or easily to be transmitted from lawyer to lawyer, wherever new parties come in or the other parties require something that has been filed. We knew it was there. The technology was available. We also knew that there were courts such as the Supreme Court of Brazil that had become paperless court. But we were, for one reason or another, still on the cusp of achieving paperless digital courts in our country. We were moving in some places towards it, but there wasn't a sense of urgency, and there certainly wasn't a sense of wanting to do something immediately. So when we finally found ourselves in a tight corner during COVID, the platforms that were available to us were largely, I won't say entirely, but largely platforms that have been developed without the specific knowledge of how legal systems work. And therefore, we had to adapt and adopt something that was made for somebody else. And I think over the period of the last 6 months, we have been able to understand what kind of changes need to be made. But this is really about processes and procedure. This is not about content. I think that during the COVID period, there is the role of the lawyer, the role of the person involved in law, or the justice delivery system is also very significantly on content. Process is what I've explained. Let's look at content as well. Content is that when things are different or things are unusual, the things are very, very dramatically different from when there is normalcy, what happens to the content of the law? The Constitution is something that gives us rights and systems which are supposed to apply in all conditions, not to be switched on and off when things are useful and convenient. Constitution must be there in the day and at night as well. Constitution must be there for us in normal times, in peace times, in the times of war, in the times of emergency, and so on. Now, of course, the instruments that are provided by the Constitution and the systems and the arrangements that are provided by the Constitution vary from circumstances to circumstances. And we know that a lot of this is based on our perception of directive principles of state policy, which address general welfare of society and address our aspiration in the Constitution and in our political history of transforming a primitive and a conservative society of the past into a modern, scientific, progressive society. Some people will say a liberal society. Some people will say a Marxist society. But certainly people will accept that a society that is fair and egalitarian, society that believes in fair outcomes for everyone, is a society that is conceived by our Constitution. And since it is not instantly possible, because you cannot overnight change society, therefore the directive principles have said we will change over a period, but this is the objective that we have. These are directive principles that will inform all decisions of the state, of governments, of parliament. These will inform all decisions because these will guide those decisions towards a culmination of greater fairness and and a progressive modern society. And fundamental rights are those that assure on the path to progression, on path to moving forward, fundamental rights will be ensured to ensure that the basic standing of a person is not disturbed. A basic standing of a person being what rights you come packaged with as a citizen of the country. Now, of course, there are theoretical arguments which I don't want to go into. Are these rights pre-constitutional? Are these rights constitutional? Are these rights to be found in any constitution necessarily, or are they to be specially found in the Constitution of India? I'll just explain that there is a difference, for instance, where people talk of rights or even talk of human rights or fundamental rights. There are some countries that think that these are only of rights like free speech. There are only countries like rights of not being arrested without a proper law. But in India, there is another very important dimension, which is an economic right. That economic rights, which are not taken that seriously, maybe in developed countries, but here, because economic right really, really matters for life and death, and therefore economic rights, the right to food, the right to education, the right to housing, the right to health, these become extremely, extremely important and are included in Article 21 as the courts have interpreted Article 21. So why am I talking about all this in the context of the COVID period? The context of the COVID period is that all these rights that I have talked about, do they get qualified? Do they get diluted? Do they get interrupted? Do they get abrogated during the COVID period? Because the seriousness of consequences that one can have by an unrestricted growth and expansion of the impact of COVID, is that something that makes it necessary that the accustomed rights that we are familiar with, those rights have to be put on hold. Freedom rights, rights to move freely, for instance, was interrupted when we were told that there would be a night curfew, or when we were told that you could not travel without a pass during the day, or when we were told that the shops would not be open, or when we were told that you could not visit the markets. Now, these were restrictions that were placed on our freedom of movement and our freedom of choice. And these restrictions would be justified under Article 19 as reasonable restrictions. These are similar to restrictions that could be placed on us during a war, for instance. During a war, the fear of air raids at night may require a regulation of using electricity, or certainly of using lamps that would be beacon to enemy aircraft to attack the city. Therefore, you may be told that you can't use light in the night, that you have to cover your windows with black curtains, because no light must show outside, and the street lights would be switched off at night. Even if your movement is not necessarily restricted, there would be no lights in the streets. And if there's a complaint that, look, I have a right to walk the streets and I must have light when I walk the streets, the answer would be, there's a reasonable restriction. We can't be doing this, because the requirement of reasonable restriction is to prevent damage to you and to your fellow citizens from air raids that would be encouraged if there was lights seen in the open, because that would become the beacon for raiding aircraft. So we know that in the state of emergency, in the state of war against peace, in special circumstances, your rights can be restricted. If there is an economic emergency, if there is a problem about the stability of banks, then your right to withdraw your own money from the banks could be limited, could be restricted under Article 19. But of course, all this would require to be tested by challenges before courts. Now, if courts were to say that your rights are restricted, but we will not look at this to decide whether this is correctly restricted or not correctly restricted, we will wait for 6 months, 1 year, 2 years, then your rights are gone. By the time you get to go to court, by that time, you may be gone and you may have nothing left. Your property may be gone, your business may be gone, your opportunities may be gone, your life may be gone. And so, how important is it for a lawyer to ensure that the content of our rights is preserved even in such circumstances is the big question. And this is not just pure theory. Let's look at two issues that were very prominent during the COVID period. One, which the court was able to decide, some people will argue, that decided somewhat inadequately, and one that the court initially was reluctant to intervene in, but subsequently the court tried to intervene. The first is the right to 4G in Jammu and Kashmir. Now, that didn't have anything to do with COVID, but I'm using that as an example because it could also have something to do with COVID. Jammu Kashmir 4G entitlement came up in Anuradha Bhasin's case in the Supreme Court, where students and colleges and schools said that the restriction imposed on 4G availability in the valley means that we cannot study online, that we have no access to education online, and the access to education online requirement may be for various circumstances, including the circumstances that Jammu and Kashmir was facing, as along with the rest of the country, which is in the COVID period, the institutions were closed. And the only way, as we did here in this part of the country, in Delhi, in Bombay, in Hyderabad or in Madras or wherever, we used 4G for communicating. We used 4G for classes, for virtual classes. We used 4G for virtual appearances in courts. This, because of the threat of violence, of terrorist violence, was felt by the government that this should be restricted, because if 4G were available, the terrorists would have an easier opportunity to plan attacks and to execute attacks. Now, we are not sure that this data about this was adequately available and furnished. The court was willing to accept a statement made by government that this is the position. The court didn't say, please show us data, that this is how it works. But the court said, we will trust you, because in an emergency, in a situation which is a life and death situation, we must ensure what the government is saying must be prima facie accepted. We shouldn't put it to a very tight test. But as a result, a lot of people believe that without any real impact of availability of 4G, without any real impact on the terrorist activity or underground activity in Jammu and Kashmir, a generation of students were denied the availability of 4G. Now, this is something that we have to ponder over and consider during a COVID period. Same thing happened with the rights of migrant labor. Migrant labor are people who travel from UP, Bihar, and other states and have gone to places like Bombay, Madras, parts of Rajasthan, Gujarat, where there is industry, where there are jobs available, and people have traveled from villages in their states to go and work in those what are called industrial or business hubs of the country. Now, that is not equally spread across the country. Some parts of it have more of business, some parts have less of business, but it could be anywhere. It could be within the state, from one part of the state to another part of the state, or it could be from one part of the country to another part of the country. Now, there is some labor legislation, there is some migrant labor protection legislation, but because there was this sudden outbreak of emergency circumstances, the systems that should be in place or are in place seem to have broken down. And suddenly, in the uncertainty that prevailed during the lockdown of COVID, a huge number of people decided to go back home to feel secure, and they decided to go back home. Now, trying to go back home, they were confronted by the situation that there were no buses and there were no cars available, and there was no transport available, certainly no public transport available. They couldn't afford anything beyond what should have been available to them. And even if they could afford, they were not even aircraft that were flying. So ordinary labor could not possibly hope that somebody would charter aircraft for them and they could get back home, because everything was paralyzed, everything was brought to a standstill. And this was the moment in which somebody had to step in. And initially, it seems that the courts were so flummoxed and they were so disoriented about the size of the challenge that they asked a few questions, but they weren't able to do anything very, very vigorously and very, very specifically. This was, of course, fortunately, a passing thing. In a week, 10 days, the bulk of the pressure had eased, but not without a lot of people dying on the road, a lot of children suffering, and a lot of real misery being inflicted on the very people who have worked the engines of our economy. Now, this is in unusual and some very, 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 very trying circumstances. This is one dimension of the COVID period. And therefore, what were we supposed to do? In this COVID period, what is the role of a lawyer? The role of a lawyer would have to be to bring this to the knowledge of the courts in different parts of the country. There were courts in Allahabad, there were courts in Bangalore, courts elsewhere, who stepped in immediately. But there were some other courts that unfortunately didn't know how to step in and what to do, and therefore not being helped by the government by adequate information, they couldn't do anything sufficiently. The same thing again transformed into another problem, and that was the problem of food. That these people who were going home and people who were already in their home districts would have suddenly the problem of food. Where would they get food if the shops were going to be closed? Where would they get food if the supply chains were interrupted and prevented from functioning? And where would they get food if they didn't have money to pay for it? And therefore, the courts had to step in with looking at some data and some information that was provided as to how people could be helped through the food distribution system, through the food security system, etc. Again, there were gaps, but some effort was made. Who could provide this? Who could fight for this? Who could struggle for this? Had to be lawyers. So the role of the lawyer for content of upholding the dignity of human beings during the COVID period was very important. I would imagine when the vaccine comes, equitable availability and affordability of the vaccine will be another question that the lawyers will have to raise and will have to bring to court, and will have to show that all the jurisprudence that we have of equal rights, of egalitarian rights, is the jurisprudence that will most seriously be required to be refreshed when this issue of protecting individuals with the use of vaccines. So the rich people can buy the vaccine. Presumably, the vaccine will be available to the rich, and they can buy it. They can go to hospital. But what will the poor people do? People who barely have enough to keep their body and soul together. People who have no roof over their head. People who are in the streets, for instance, people who are at the bottom rung of the economic ladder, how will they be able to get access to the vaccine? We do know that there is a health protection system, but the health protection system is not yet, the coverage is not anywhere near where the food protection system is concerned. The ration cards are more widely available in our country, but there was an issue that if you had a ration card in Maharashtra and you moved back to UP, would that ration card be usable? And the courts there in the past have said that in such a case, as there was the case of floods, the ration card of one state should be utilized and be used in another state as well. The same assurance was given by the state, by the government to the Supreme Court, saying that we are going to turn these ration cards into portable cards. So wherever you have a card, it would be used and be usable in any other part of the country if you were, of course, able to explain why you were moving from place A to place B. Now, this was also possible because the lawyers brought this matter to the courts and ensured that the courts would have something of this available to them to direct the government to ensure that people who left their temporary homes and went back to their permanent homes were not left high and dry. Similarly, many other issues have arisen. Now, the issue about what to do with education, with schools, there again, the lawyers are the ones who have brought these matters to courts. The Calcutta High Court has just recently given a judgment that for this period of 6 months to 8 months that COVID will continue, for this period, that there will be certain restrictions on what could be charged. For instance, the fees, which is the tuition fees, can be charged, of course, with a reduction of 20%, but no fees would be charged for those things which are not being used, such as bus fees, because children are not going to the buses, or special project fees that was charged by schools because those special projects are not being done. And the courts, of course, have asked both lawyers as well as accountants to sit down and come up with solutions, those that will ensure that the schools don't suffer such an irreversible economic pressure that they have to shut down, and at the same time ensure that people who can afford to pay for education, and as they have been for years together, don't use this as an excuse to deny the school what is legitimately due to the school. And at the same time, people, for one reason or another, because they belong to a group that is suffering a special disability, or because of their personal circumstances of their families, they are suffering a special disability in terms of being able to pay fees. There are also some solutions must be point decide that they bring either amongst remains. How do you, and to what extent do you reduce the rights when there is an emergency, when there is a war, when there are very special circumstances? Now, some people believe that when there are special circumstances, you can restrict even ordinary freedom, that you can impose incarceration on people if you want to protect society from dangers of certain circumstances that have arisen, that you can put people in prison. Without trial, you can put people in prison, or you can deny them bail that they would otherwise in ordinary circumstances would have bail. Now, these are open questions, and I believe these questions are something that are part of the role of the lawyer. That when there are unusual circumstances, how much, to what extent, and when, and for how long can you restrict the rights that we are accustomed to? I believe that we are sometimes all too willing to restrict rights without there being adequate justification for restricting rights. Whether it's freedom of speech or its movement or its dignity of a human being or freedom from incarceration. I think that we should be extremely careful in difficult times not to give up our basic commitment towards freedom. And that's where I believe the lawyer, the judge, the entire justice delivery system has a very important responsibility. The doctors have a very great responsibility and they perform a very noble job. The policeman has a great responsibility. The service providers have a great responsibility. The teachers have a great responsibility. Community leaders have a great responsibility. But no less is the responsibility of the lawyer and the judge in times of COVID, in times of emergencies, in times of war, in times when things are unnatural and not normal. I believe that role is a very significant role, and we must remain conscious that that role has to be performed without fear, without favor. Thank you very much, ladies and gentlemen.
Thank you very much, sir, for your valuable and prestigious word. Now, I would like to start with the question answer session. Can I start, sir?
Yes, please. Yes, please.
Okay, sir. The first question is whether there is a possibility that e-courts would become a part of the norm as the restriction starts dissolving day by day.
Well, I hope not. I hope not. The restrictions must be the least possible. The judgments of the Supreme Court that have introduced the concept of proportionality, I think it should not just be used to give ourselves comfort, but proportionality should be very carefully applied in all cases so that whatever restrictions are placed in view of unusual circumstances must be restrictions that must be the least minimum restrictions that are required, and it must be manifested and clearly shown that those restrictions work to that level and are required up to that level. We shouldn't casually assume that the restrictions are a solution. Just as a doctor is very about medication and telling you how many tablets to take, it's not to be left to a quack to say, well, if you feel better with one tablet, you'll feel even better if you take 2 tablets or 3 tablets. That's not the way that we should resolve the issue of rights. We have to be rigorous in our analysis. We have to be careful with the data, and we must be very cynical about easily assuming that restrictions are necessary to protect ourselves. I think freedom is necessary to protect ourselves, but we do know that freedom's regulation, Article 19's reasonable restrictions, which now should be seen in the form of proportionality, is permissible in the Constitution and it's sensible, but we must not use it just as a word. We must apply it with care and we must apply with responsibility.
Thank you so much, sir. So the next question is asked by most of the students of ICFAI University is that how to improve the legal profession during COVID-19 pandemic. So can you please share your views regarding that?
Well, the first thing you need to do is to insist that the court systems have better platforms and platforms that are specifically designed to be used in a court system. I think we haven't reached there yet. And then once we get that, we all as lawyers, young and old, have to learn to be able to use those systems effectively. If we know how to use those systems effectively, we will be able to achieve a great deal that otherwise will go missing. And the complaints that people make that virtual hearings are not as effective as physical hearings, I think is something that could be eliminated almost entirely, if not 100%.
Thank you so much, sir. So the next question is there any chance that there will still be e-filing of cases and online hearing even after the completion of COVID phase?
Well, e-filing is no problem. I don't think anyone's complaining about e-filing. E-filing is now very easily done, and your ability, your opportunity to be able to keep track of your filing, I think all that is something which is non-controversial and on which there's no disagreement. We just have to ensure that the capacity is always adequate and that the system works without flaw. But whether the same can be said about physical and digital hearings, I'm not too sure. There is a house is divided on that. Some lawyers say that we must get back to physical hearings as quickly as possible. Some lawyers say there should be a mix of the two. Some lawyers say that the e-hearings should go on. But I think over a period, people will be able to take a call. And I suspect ultimately it'll be 50-50. There will be some e-hearings that will continue, and there will be some physical hearings.
Thank you so much, sir. So the next question is asked by Professor V.P. Tiwari. That is, could you please also throw some light on the plight of junior advocates who are still suffering due to closure of courts and no work and no income?
Well, this matter is right. I mean, it matters more to us because we are lawyers and we are in the system. And some of our young colleagues we have worked with, and we feel a sense of belonging with them. The matter has come up before various courts. It's come up before the Supreme Court. The Bar Council have been asked to suggest what can be done. It's a very, very, very huge problem. But this is not only for lawyers. I mean, if we are fair to ourselves, we know that this is a problem that exists elsewhere too in the system. Loss of jobs. A large number of people have lost their jobs. We don't even know because you won't see them every day. But as far as the legal system is concerned, we know by the very presence of young people and knowing that there are so many young people coming into the system every year. I mean, there will be lawyers coming this year. Where will they get started? Where will they do? Where will they go? I think it's a serious problem. The Supreme Court has taken cognizance of this matter. I hope that collectively between the bar associations, the Bar Council, the Supreme Court, and the senior lawyers of the country, we'll find some way of reducing the stress that the younger bar has had to feel because of this.
Thank you so much, sir. So the next question is the new Code of Wages Act relevant for migrant workers suffered for COVID pandemic?
Well, this is a controversial thing. The labor legislation that has come, there are many different points of view. I think that they all require much more dialogue, including with organized labor and unorganized labor. I think we need to do a lot more dialogue in order to ensure that we don't end up taking decisions during this period where people's voices may be distracted or people's voices may not be may be heard in a concentrated manner. So I would recommend that we don't do anything in a hurry about wages, but we do something urgently about ensuring that the stress of this period is taken care of. There are countries that have found ways of doing it. Of course, some of them are very rich countries, much richer than India, and therefore they have been able to find suitable answers. But I'm sure India too can find an answer. I'm sure that there is an answer. We can have a large budget for food security. We can have a large budget for health security. We can have a large budget for pensions and indeed for other important areas of governance. I'm sure that we can find the budget and we can find the money to ensure that the labor doesn't suffer unduly during this period.
Thank you so much, sir, for answering the queries of the participants. Now I would like to invite Mrs. Monica Kharora, ma'am, Academic Coordinator of ICFAI Law School. Over to you, ma'am.
Thank you. Thank you, Ekta. Am I audible?
Yes, please. Yes, please.
Thank you, sir. It's my privilege and honor to be giving this vote of thanks to sir, who's a great personality in himself as a lawyer and as a great politician. Sir, your talk and your lecture was highly enlightening, and the students have got a clear perspective of how this pandemic has influenced and what was the role and how the lawyers have come up and lived up to that expectation. Right from the beginning, when you started with how human beings respond to uncertainty by falling back on the faith and their belief in God, that is what I think it binds all humanity. And wherever, whatever we are, from whichever religion or whichever part of the world we come in, we felt a sense of unity in that one humanity. And our response was also to fight this pandemic as one. And it has given us great comfort, at least in that sense. And sir, as you rightly said, that the courts, their accessibility in such times of emergencies are very important for us to protect our rights, and therefore as students of law they have to be more conscious of how they study the impact of the fundamental rights, the directive principles of state policy, and how we as teachers are able to tell them of what we need to do, and how as lawyers we need to work towards protecting the rights of the people. And sir, you have pointed out at very important points, especially the economic rights of the people. And it was wonderful listening to the lecture. There are several comments from the participants who have been, floored by your down to earth talk. And sir, the clarity of thought, we are thankful to you, sir. And on behalf of ICFAI University, Dehradun, I thank you for giving us the opportunity to hear you. And we wish that in better times, we are able to welcome you to our university. So thank you once again, sir, for being with us.
Thank you. I look forward to that. I certainly look forward to that. Thank you. And good luck to all of you. Good luck to all of you. All the best.
Thank you, sir. Thank you very much, sir.
Thank you very much.
Gee.
Thank you. Thank you very much. Thank you.
Thank you. Sir, it was very much enriching and enlightening. And our participants in this chat box, if you see, they have said that it is an excellent lecture, and they have appreciated very much the talk we have given. So we are very much thankful to you, sir, for sparing your valuable time and giving us this opportunity. Thank you, sir. Thank you very much, sir.